Again, we're just letting folks get logged in. If you have initial questions, you can use the Q&A box to submit those questions. We've still got some folks coming in, so we'll just give them a minute to get settled and then we'll get started. Thank you all for joining us today. We will now get started, and I'll turn it over to ASH Executive Director, Laurent Hubert.
Thank you, Megan. So welcome, everyone, and thank you for joining us today for this webinar hosted by ASH and Corporate Accountability on Article 19 of the FCTC for non-lawyers. And I'm assuming most of you, a lot of you know what we're talking about. We're talking about Article 19 of the FCTC, but this is, as you may all know already, Part 6 of the FCTC addresses questions related to liability, and Article 19 is the one that encourages parties to consider taking legislative action or promoting the existing laws to address criminal and civil liability, including compensation where appropriate to deal with tobacco harms. So we're very fortunate to have a great set of panelists today. And as you all may know, also this topic, Article 19, is on the agenda of the next round of negotiations for the Framework Convention on Tobacco Control, COP11 of the FCTC. And through coordinated advocacy and collective work, we can facilitate a robust outcome at this upcoming COP through hopefully a decision that can facilitate the use of litigation against the tobacco industry in the future. So we have 4 panelists today who will address the topic of liability for non-lawyers in the context of Article 19, covering terminology, background, how to use it, and the benefits and challenges associated with using this. The concept of liability to advance tobacco control and health. If you have any questions, feel free to use the Q&A function at the bottom of the screen and address them to a specific panelist if you wish to do so. So we'll introduce the first speaker, who will then introduce the following speakers. So Daniel Dorado, he's the Tobacco Director, point person for corporate accountability. He's a lawyer and has been working on this issue for already a number of years. Daniel, the floor is yours.
Thank you so much, Laurent and ASH team for co-hosting this webinar. On behalf of Corporate Accountability, it's always a pleasure to partner with you, but also to having the chance to continue amplifying the knowledge on this particular provision that now that we are commemorating this year that we are commemorating the 20 years of entering into force of the Global Tobacco Treaty or the World Health Organization Framework Convention on Tobacco Control. At the personal level, and basically this was one of the reasons of why I joined this global tobacco control movement, always brings me hope and see how this particular provision has been escalating over the years. And that's why we are here, because when we hear, and I feel that some of the audience that are also joining today. I see that, and I'm glad that a lot of experts in the topic also accept the invitation to join a webinar for non-lawyers, because I feel that I'm a lawyer, and I always approach to this topic saying, if I am not able to explain what I am working on, for example, to my mother that is not a lawyer, probably I'm not doing something well. So with Ash, we always talk about how we can manage this type of conversations when we approach to government delegates that, among others, will participate in these upcoming meetings in November in Geneva. So this is the challenge for all of the speakers today. And with this quick introduction, I'm very pleased to introduce my colleague, Kelsey Romeo-Stuppy, a managing attorney from Action on Smoking and Health, who will be giving us some remarks and some preliminary concepts on the legal terminology that will allow the rest of the speaker to jump into the topics that we invite them to present. The floor is yours, Kelsey.
Thanks so much, Daniel. Looking at the participants list, I see a lot of lawyers. You people can't even help yourselves. You can't stay away. But before I get started, I wanted to give a little caveat. We titled this Article 19 for non-lawyers because we wanted to make sure we were breaking down this topic and making it seem a little less intimidating. That is in no way to say that there aren't non-lawyers who are experts in this, because there absolutely are. There are plenty of people, including people on this panel, who are not lawyers but are still experts in Article 19. So I just wanted to highlight that diversity of experience as well. It's not just lawyers who work in this area. Okay, so before we even get started, we have people from a wide variety of backgrounds. So I wanted to give a little terminology. The FCTC is the Framework Convention on Tobacco Control, or the Tobacco Treaty. I assume everyone here knows that, but just in case. The COP is the Conference of the Parties. When we say COP, we mean the Conference of the Parties of the FCTC. Article 19 is the FCT article on liability. You'll occasionally hear us say the Secretariat. That's the staff that supports the treaty and the COP. A decision with a capital D is a formal policy adopted by the COP. And then liability, we're going to talk about in depth, but the basic definition is the state of being responsible for something, especially by law. So who is responsible for the harms of tobacco? Our first big issue is that in Article 19, it says both civil liability and criminal liability. When I talk to newcomers to this area, I think this is often the first place where we start to get a little confusion. I'm an American and I'm barred in the United States, so my concept of law is skewed in that direction. This is my second caveat of the day, but there's always exceptions to everything. So I'm going to tell you the general rule, but of course there is an exception. And different countries have slightly different legal systems, but generally this is what we mean. Civil liability, the goal is to resolve a dispute between two parties. It usually results in a financial award and money, and occasionally there's other things like injunctive relief, forcing an offender to stop doing something. This is in common phrase what we usually call a lawsuit. Criminal liability is what you see on TV all the time. It's to punish offenders for offenses to society and deter behavior in the future. It can also result in money, but the money is a fine, so it doesn't go to the victim. Usually it goes to the state. It can result in probation or imprisonment. And a key factor here is that it requires the government to prosecute. So I cannot bring, in most cases, a criminal charge against someone of my own volition. I need a government to do that. This is my very simple way for us to remember this moving forward, because we're going to get more complicated. Civil liability is money, criminal liability is handcuffs. I think that will be helpful. Oh, I'm sorry, I skipped one. So there's a couple very famous civil liability cases in the US around tobacco. The first one is the United States v. Philip Morris, which we sometimes call the DOJ lawsuit or the RICO case. I think a lot of people are very familiar with this one. and it's been used worldwide as an example. If you'd like to read more about this case, I don't have a lot of time, so I'm not going too in depth. The Public Health Law Center has a great overview, as do a lot of other organizations. The other one is the Master Settlement Agreement, in which I think it's 46 U.S. states sued the tobacco industry for a settlement of funds for their harms. And that is a great example because it's just a very clear example of a lawsuit in which tobacco is involved. So that one's pretty straightforward as well. Criminal liability is a lot less straightforward and a lot less settled law at this point. So let's dive in. I think one of the more interesting cases recently was in the Netherlands. They tried to bring a case in which they proposed charges against a tobacco corporation and the executive, so both the corporate body and people, for attempted murder, manslaughter, aggravated assault, and forgery. In addition to the lawsuit, they led a very large communications campaign, and ultimately more than 24,000 people in the Netherlands endorsed the campaign. And many organizations also joined the indictment. It was appealed and appealed and appealed, and it made it to a top court. And the judge agreed that the arguments of the plaintiffs were correct, but didn't think that it was an issue for the criminal courts. He referred the issue back to the legislature. This has been tried in a couple other places as well. And there are a lot of different areas of law in which criminal liability could come up. This one in particular focused on, they called it the rigged cigarettes. It was that when you hold a cigarette, you close the holes around the filter, which meant that essentially, allegedly, there you go, I'm a lawyer, I didn't forget the word allegedly, the tobacco industry was lying to the consumers. So this was focused on that area, but there are a lot of different areas of law in which you could file a criminal charge. Okay, now we have the basics. Are you ready to level up to level 2 here? We get a little more complicated. Administrative liability, which is under civil liability for the most part. There's a couple different forms of administrative liability. One is lawsuits in non-court tribunals. One example from the expert group report that just came out is the Central Pollution Control Board in India, which took administrative action against tobacco companies. So that's a like a local government board taking action. So that's one form of administrative liability. Another form is a lawsuit against a government agency. We could also call that administrative liability. And ASH was involved in one recently in which our partners at the African American Tobacco Control Leadership Council, ASH, the American Medical Administration, and the National Medical Administration filed a lawsuit against the United States Food and Drug Administration. So we filed as NGOs a lawsuit against the US government, or part of the government, the FDA, and that was for their inaction on menthol cigarettes. So essentially their failure to protect the people they're supposed to be protecting. So that's another type of administrative lawsuit. Here's our level up for the criminal side. I mentioned this a little bit already, but we get into issues of corporate personhood. If the corporation is doing the crime or the problem, not the person, how do we deal with that? And if a corporation is a legal person, we can't put them in jail. So if they're found guilty of a crime, what can we do? One thing that's been proposed is the corporate death penalty, which is that they could be ordered to dissolve. So that's one area of law that I think could be interesting moving forward. Another sort of hybrid area is human rights litigation. This is proactive litigation where governments or people are charged with violating the human rights of citizens for their failure to protect them against the tobacco industry. It depends a lot on what court this is filed in, what arguments are used, etc., about whether this would be civil or criminal. And then a long-term, more academic exercise, but maybe actuality someday, is something like the International Criminal Court. Could the tobacco industry be held accountable at the highest international level for their, crimes against humanity. So what does this all have to do with our COP moving forward, our Article 19 decision? Daniel's going to get into this in a little bit, but I just wanted to get us started. At COP 10, there was an Article 19 decision that formed, and one of the things it did was reformed an expert group in this area who published a report, which I just referenced, and I think Daniel will talk about a lot more. But the next steps for this decision were that the expert group collected information about all these processes from around the world, which is incredibly useful because sometimes the right hand doesn't know what the left hand is doing. And maybe we have a prosecutor in California who wants to take cutting edge steps against the tobacco industry, and maybe we have a model from India to share with them. So I think that's hugely important. We want the parties to use these tools, and moving forward, thinking about a COP 11 decision, we want to encourage the recommendations made by the expert group and to continue these goals. Sorry, I know I threw a lot of information at you fast. I'm happy to answer any questions after all of our speakers are done. And thank you so much for having me.
Thank you so much, Kelsey. A challenge task, but I also think that you paved the way for what I am going to present really quickly. This role of co-moderator and presenter also put me in a challenge position, but I will try to do my best in both roles. So it's my turn to change to my presenter hat. And when Kelsey, Lauren, Megan, and I were talking about how we can concisely resume 20 years of history of this particular article provision, well, and again, in this exercise to trying to explain or have work conversations with my mom, I thought, and something that we like to chat about is a TV series. So I'm trying to become a little bit creative and articulate what is called the 5 minutes mini-series of 20 years of history and developing on this particular provision. If we go to the next slide or first episode, Megan, please. I'm not seeing the next slide for some reason. Thank you. And some of these images that are in this first episode that I intended to call From Promise to Progress, and I wanted to assure that this is going to be a mini series. It only has 3 short episodes. Builds from what Kelsey already explained in some of the legal terminology. There was this major big moment in which you will see there the New York Times photo where the top executives of big tobacco corporations oath upon the US Congress that their products do not lie, do not kill anyone, and well, a lot of deaths were taking place and continue taking place. So there was a need of a global response, but a global response that addressed holistically all the consequences of this global epidemic that, as many of you know, causes more than 8 million deaths over a year. Kelsey already shared some of the major efforts that were taken, among others, but particularly on what regards to litigation or legal cases, was this famous master settlement agreement, in which I see that some of the attendees today follow very closely. But what I wanted to share with this episode, and I feel that these 2 quotes from these 2 experts, Professor Dick Daynor and Irene Reyes, synthesize it really well. While commemorating the 20 years of existence, honestly, and personally, I feel that the Global Tobacco Treaty is unique in all the provisions that it has. I'm not aware, hopefully others, and if you can share, that will enrich the discussion. But I'm not aware of an international instrument that addresses liability in the way that the Global Tobacco Treaty encapsulates, and as Kelsey already explained it. And these two experts were calling about the need of keep advancing and implementing liability, because when we go to the global treaty and some of the questions that you may be start answering, why, if there is an international legal instrument that already contains a provision, why in these 20 years there has not been like any major case to hold the tobacco industry liable? And the other two speakers will start sharing of some experiences, but particularly a case that uses this provision, because the other cases uses like the national legislation as the Article 19 encourages, but many, currently you all will be surprised how many governments all over the world are not aware that this particular provision of the Global Tobacco Treaty exists. If we go to the next slide or episode, Megan. So more or less what I was talking about took place in 1994, 1998, and we escalate to 2003 when the Global Tobacco Treaty entered into force. I will not go into too much detail, as Kelsey already addressed, but in the screen you will see that this international instrument encapsulates or took the path of including in two particular provisions, article or points of the treaty, the issue of liability. One, as a principle, and when we say as a principle, is something that covers the integrality of this instrument. So, like trying to say this in other words, some cooking recipes, if you don't have like the stove or something to put to translate that recipe that you have without the stove, without some elements to cook, well, that recipe will not be able to transition. So this principle is more or less all those tools that needs to be taken into account while implementing the provision. That is the text that you see on Article 19 and that Kelsey already explained. So all this to say that this is how the Global Tobacco Treaty encapsulates the power of liability. And if we go to the third episode or next slide, this is how, and I try to bring a lot of images because 3 slides will not make justice on all of the efforts that currently more than 183 countries have been made to give form to this article or provision that I already referred to. So succinctly, and I call milestones, I will say that, or be very ambitious to articulate that the first milestone that took place in this international global space was the discussions that all of these countries were having, as the discussion that we are having today. So we have this provision, what are we going to do next? So all of the legal terms that Kelsey brought were more or less the discussions that all these governments were having. So what is liability? What are the difference between all the legislations that we have? Do we approach to civil liability in some countries the same way that other countries made? If we decide to take this forward, how much this will cost? So in these 4 major meetings, the third one that took place in 2018 was an outside meeting, but I am bringing this because all what happens in the international space not only take place every 2 years with all of the countries that are members of this international instrument came together, also the treaty applies every time. So that's one of the key messages of this mini series that I wanted to share. Article 19 should not be something that we bring every 2 years to say, well, there is something that we need to do. Everyone needs to take, and all of you that are here and all the people that are supporting this movement have the big responsibility of bringing Article 19 to the conversations. In these 4 major moments, the governments decided that there was a need to bring or conform some people, and this group of people is called expert group, that could present and review all what is out there in all of the legislation of these 183 countries to provide recommendations or provide tools on how these countries could move forward. So in 2016, these recommendations were presented. I will not go into all of the details. That will take, this will transform the miniseries into a movie, I could say. But what the expert says were that, yes, that there are several challenges, but they offer a recommendation of developing a digital tool that is called the Civil Liability Toolkit, that basically is an online tool where you start to resolve some questions. So say your country has a legislation to initiate any legal action against tobacco industry, you answer yes or no. And when you answer this, it starts giving you a path to review what is needed to start this legal action. If we go to the next slide, and probably as you all may start inferring, this was not enough. Well, yes, not all of the countries may be able to use this tool, or if they use it, how they move next. And I will take some of the words Laurent bringing at the beginning of the presentation, basically saying, yes, there is a need to continue doing, and that's 20 years could sound a lot for an international instrument to develop tools to approach two topics. But in terms of the progress that has been made, personally, I think that has been a lot of efforts to shape such as complex discussions. And there are things, of course, more things will be done, and other panelists will talk more. But if we go to the year 2024, the discussion came back again. So what took place in 2018 was not enough. And there was a need to keep reviewing because other governments were doing cases. One of those governments that is here with us today is Brazil. They start initiating some actions. There was a lot of things or discussions around many of the legal actions that have took place and that Kelsey mentioned have took place in the United States or in Canada, but how Global South countries could initiate this costs a lot of money. So basically, all governments decide that there needs to be more discussion. In the meantime, a legal expert database, another digital tool was pulled forward so that governments could consult or address questions to legal experts in the regions when they need support to initiate the cases. And this was launched last year. So another tool and another progress. And if we go to the next slide, and with this I will end for the moment and set the scene for what Cynthia and Vinícius will discuss, is the second milestone of this episode 3. What is coming next? So Kelsey and Laurent already mentioned these 183 countries will come together in November to discuss and review the additional recommendations that this group of people from around the world put on the table so that they can continue analyzing and strengthen some current cases or legal actions that are taking place. This document is a 48 document pages. It gives around 30 suggestions to advance in several of the layers that Kelsey described: civil liability, criminal liability, administrative liability, around human rights. And well, definitely this is a gap, a tool that needs to be used. And of course, it will rely on parties to take the decision on how they continue transforming these tools and could continue shaping the scope of the liability provision of the Global Tobacco Treaty. So for the moment, I will leave it there. The final slides, I will save it for my other co-host hat at the end of the presentation. But now it's my pleasure to give the floor to my dear colleague, Cynthia Callard from Canada. Cynthia works with the Physicians for Smoke-Free Canada, and she will be providing additional remarks, particularly on the Canada experience and how Canada has been contributing to not only shaping the legal actions and ways to approach to litigation around the world, but how particularly liability has helped Canada to advance and hold the tobacco industry accountable and liable for their abuses. Over to you, Cynthia.
Thank you. I'm just going to figure out how to share my screen here. There we go. So it's impossible to condense 27 years of litigation into a 10-minute overview, but I'm going to try and hit some of the key points. There is a longer version of this presentation that's available, and I'm around and able to answer any questions. People should feel free to email me with any specific requests on this long and complicated file. Since at least the 1980s, Canadian tobacco control groups have advocated for governments to sue tobacco companies. And if you judge the results of our efforts by the number of lawsuits filed, we were successful. Canada is one of the few countries outside of the United States where tobacco lawsuits have been actively pursued. And in recent years, more than half of the world's tobacco lawsuits were filed in Canada. Canadian lawsuits were very much inspired by the US cases of the 1990s, but they did not progress as quickly or as smoothly as they did in the United States. It took just over 4 years from the time that the first United States government, Mississippi, filed a claim against tobacco companies until the Master Settlement Agreement was reached in 1998. In Canada, it took more than 27 years from the 1998 claims by the British Columbia and the Quebec class actions before there was any resolution or restitution for the wrongdoings committed in the last century. None of the claims made by any of the 10 provincial governments went to trial. The only judicial review of industry activity was in connection with the Quebec class action suits. The team of lawyers leading these twinned cases took 13 years to get their case to court. It was one of Canada's longest and largest trials, with more than 250 days of hearing, which took place between 2012 and 2014. These lawyers worked on a contingency fee basis, and before the end of the resolution this year, they had logged 200,000 hours of work without pay. The 42,000 exhibits that were registered in the court can be found in the Legacy web document database. I took this picture attending the trial. The Quebec Ministry of Health paid for a daily report to be made of the trial in English and French as a way of encouraging people to understand the wrongdoings of the companies. This trial resulted in a massive victory for injured Quebec smokers and a stunning loss for the companies. Both the initial court ruling in 2015 and the review by the appeal court that was issued in 2019 strongly condemned the ways in which the multinational companies operating in Canada had hidden the truth about their products and had conspired to delay the adoption of health regulations. Among the laws that the companies were found guilty of breaking was the Quebec Charter of Human Rights and Freedoms. This case can be cited as an example where human rights law were used to hold the companies to account. But before the Supreme Court could uphold those two decisions, the companies pulled the plug on the trial system. They used Canada's insolvency law to suspend all lawsuits. They shifted tactics and claimed they wanted a settlement that covered all of the cases against them in order that they be able to remain in operation. To achieve this legal ceasefire, they needed the majority of their creditors to agree. The provincial governments all supported this route. Secret negotiations between governments, class actions, other litigants, and tobacco companies dragged on from early 2019 to mid-2023 with absolutely no apparent progress. In the fall of 2023, the Chief Justice of the Ontario Superior Court stepped in. Frustrated with the delay, he ordered an arbitration process. He directed the former Chief Justice, who was acting as a negotiator in the settlement, to take matters into his own hands and to draft a settlement proposal. 1 year later, a year ago tomorrow, that draft plan was made public. A few weeks later, it was approved by everyone suing the tobacco companies. And although some of them initially opposed the deal, the companies eventually withdrew their objections. Health groups, which had been given modest standing during the insolvency process, voiced their objections to provisions of the settlement, but their concerns were dismissed. The plan was approved by the court in March 2025 and came into effect at the end of August. So what does this plan do? The hint is in the title. It's a plan of compromise. The resolution will end all tobacco claims for harms incurred up to the point it takes effect, including claims against the multinational owners. It will provide 32 billion Canadian dollars in compensation. Most of that money, 20 billion, will be transferred over the next 20 or more years. These payments will only be made if the companies make money selling tobacco products. The payments are entirely funded based on continued tobacco sales. In essence, the plan transfers 85% of the revenue from tobacco sales to provincial governments until their debt is paid. That percentage actually falls to 75% after 10 years. The agreement does not impact the profitability of vaping or heated tobacco products or their marketing, because the settlement requires that the sale of these products be hived off to a new corporate structure. The settlement also requires that the companies maintain their usual business practices, even though these business practices are known to be harmful to health. The plan is drafted to ensure that the companies did not go bankrupt or have to go into receivership as a result of their lawsuits. On a financial basis, the resolution is a questionable outcome for governments. During the insolvency process, an expert was hired to calculate the past and future costs to government of treating the diseases caused by smoking initiation during the period of wrongful behavior in the last century. This account reached almost 1 trillion Canadian dollars. Importantly, the revenues that governments will receive in future settlement payments and taxes are unlikely to cover the healthcare costs that result from continued smoking. Governments could have received the same amount of money that they're receiving in the settlement if they had raised their taxes by about 25% over the last 2 decades. Governments will receive about 2.5 cents on the dollar of the damages that they received. Injured smokers will receive about 30 cents on each dollar that was awarded by the Quebec courts. Assessed as a public health outcome, the settlement also comes up short. It contains no measures, zero measures, to reduce tobacco use, no new requirements that could be seen as related to tobacco control or as public health. This is not for want of trying on the part of the health organizations. I've listed here the formal requests that were made to provincial governments casually in an advocacy setting during the insolvency process, and those that were made in front of the court as part of the settlement review. None of these were put in place. Nor did the provincial governments have any form of consultation or formal dialogue on the terms they were seeking on the settlement. In Canada, the opening of a public park would receive more public oversight than the settlement negotiations did. Up to the last moment, the Canadian Cancer Society and the Heart and Stroke Foundation attempted to influence the plan by requesting the court order adjustments that would make it more fair and reasonable. These were turned down. This deal may not have been what we hoped for, but that does not necessarily mean that we're not better off for it. Can we say that the governments won their case? Can we say that the companies lost? Well, cigarette sales will no longer be profitable for manufacturers in Canada for some time. Provincial revenues will be higher, but it's not clear whether that will make it easier or harder for us to get new measures to reduce tobacco use. From a public health perspective, the outcome is far from clear. In hindsight, the absence of health measures in the outcome may be traced to the way in which these lawsuits were managed by governments and by the way they were managed and addressed by civil society. I won't dwell on what we did or failed to do over the past 27 years, but I have listed some observations for future reference. Tobacco lawsuits were the first government efforts in Canada at addressing health harms caused by corporate activities. New lawsuits are now being prepared or are underway for opioids and for social media and vaping products. Hopefully, the experience we had with tobacco can inform our engagement on these files and can make these lawsuits have a public health impact. From the perspective of the FCTC Article 19, there are also some striking shortcomings. It's important to remember that the Canadian suits began before the FCTC was drafted, let alone implemented, and they were essentially, provincial governments have not in Canada taken much notice of the FCTC, and it appeared to have taken, never made any reference to it in the management of their lawsuits. The treaty calls for governments to consider lawsuits as a tobacco control measure. If you look at the text, it says, for the purpose of tobacco control, the parties shall consider taking legislative action or promoting their existing laws. We don't know whether our governments did consider the legislative action within the context of tobacco control or not. They've never told us, but it would appear not to have happened in Canada. Article 5.3 guidelines call for transparency with interactions with the industry. The willingness of Canadian governments to negotiate with companies in secret for many years falls short of that expectation. I maintain a blog with updates on the developments in Canada. As I said earlier, if you need any information, please don't hesitate to contact me, or you can find more information on the blog. Thank you.
Thank you so much, Cynthia. And yeah, definitely, as you say, synthesizing 27 years of litigation, hard. I think that you have made an outstanding job. But probably I will also say this is a demonstration that this is possible. And I will probably build in some of your closing remarks. Liability is also a tobacco control measure, and probably there is an invitation for those non-lawyers and from all the tobacco control community, and the progress on Article 19 is showing, and I feel that this is a good transition for our next speaker, that there are ways, as we always hear in this international space, this famous word, political will. Political will also needs, and when they mention political will of mobilizing governments, always needs to take place from people, and those ones that are attending today. The broader tobacco control community has been doing an outstanding job also sharing what is going around Article 19, supporting governments. So with this, it's my pleasure to give the floor to the next speaker, Vinícius Fonseca. Vinícius is an attorney for Brazil at the Solicitor General Office. He will be sharing some remarks of a recent litigation case. Brazil is moving forward. So over to you, Vinícius, and Brigado for being here with us today.
Thank you very much, Daniel. Can you see my screen?
Yes, but it's not in presentation mode yet.
That's it. Yep.
Yeah, now.
Thank you. Thank you very much, Danielle. Thank you very much for all the ASH team for the opportunity to speak about our case here, our case, Brazilian case. And it's always a good thing to do. And I see that the audience is not supposed to be lawyers in the audience, but I see that we have a lot of lawyers in the audience, but I'll try not to be that technical. So we're talking about Article 19. You've already know a lot about Article 19 at this point, but just to highlight in the Article 19 what we are doing in Brazil. We are, yes, enforcing Article 19, and what I highlighted here is what we're dealing with. So we are promoting our existing law, so we didn't create a new law to sue the industry in Brazil. We use the law, the legislative framework that we have in Brazil to deal with civil liability of the industry in Brazil. I will explain that, including and specifically here compensation. So you need some context on Brazil, the reality here. So the reality is that in Brazil we have a universal and free healthcare system. Is a public universal and free healthcare system, and we have a massive burden of tobacco products on public health and on this system. So the idea here is that every Brazilian, every citizen, to some extent, contributes to the health system through taxes, because it's free. The healthcare system is free, but is not free because every citizen in Brazil pays the taxes. So if the industry is burdening the system, the idea is that the industry is burdening on Brazilian society. So the idea here is that every Brazilian is a plaintiff in this case, represented by the Attorney General's office. And I'll explain the specificities of the case, but the idea here is that. This is a civil liability lawsuit that we have in Brazil with both human rights and law economics approach. Human rights because we are here dealing with public health and as a diffuse right, as a human right, and the law economics approach. The idea here is that the industry, they take the profits from selling the cigarettes in Brazil, but the burden, all the burden is for the society. So they are not internalizing a burden that should be of its activity. This is our thesis here. So we filed this lawsuit in 2019, in May 21st. The project initiated 2 years before because we needed to study a lot. So we studied the Canadian case, we studied the case of the United States, and we studied a lot our legislation in Brazil. The individuals, they don't have success in this kind of litigation against the industry in an individual perspective against the industry in Brazil, but we have a totally different approach in the case that the state sued the industry here. The plaintiff, so is the Brazilian federal government, is the União, we call Union, and the defendants are two groups that own 90% of the market share of sales of cigarettes in Brazil, which are BAT and Philip Morris. We sued not just the Brazilian subsidiaries, but also the foreign parent companies. The main claim here is the reimbursements of the state healthcare costs with tobacco-related disease. And the legal grounds is more for lawyers, is both street and fault-based liability, but the main idea is that we have legislation in Brazil. We are just using the legislation that we already have. Together with the petition that we filed in 2019, we attached more than 400 documents, and most of them was to show to the judge, to the judiciary in Brazil, but also to the society, all the misconducts of the industry through the years. We have a particular legal framework in Brazil, so this is more for the lawyers, but also for all the public. They may be thinking, oh, is it possible in my country or not? What we have in Brazil, we have a class action system that's kind of similar to the US class action, but is not the same. Multiple entities can act as a plaintiff in this class action system, and the state is one of them, and we use that. It is affordable, so you don't need to pay a lot of fees or huge fees to use the system, and it protects diffuser rights. So as I said, we are protecting here the public health as a diffuser right and as a human right. We have in Brazil judges specializing in health rights. This is a good thing for us. And we have a comprehensive legislation about civil liability, which we use in the case. And also, Daniel was talking about that. We had something really important that was the political will from the Attorney General's office. We had at that point, and we have now, and we always had. The Attorney General always supported the case. We had, I guess, 4 or 5 Attorney Generals in this period since 2019 to now, and every Attorney General supported the case, and I don't see any other Attorney General not supporting the case. So we should not just the Brazilian subsidiaries, as I said, but also the international headquarters that was important. And I can say that the foreign companies, although they are not Brazilian, they presented the defenses, so they are defending themselves before the Brazilian judiciary. This is something huge. And we're claiming reimbursement for 26 diseases for the treatment in public healthcare system of 26 diseases that have proven and it's proved that it have epidemiological nexus with tobacco consumption. So there is no doubt that these 26 diseases are caused because of smoking. So we relied on the Surgeon General's report, the U.S. Surgeon General's report, which is the best piece of evidence that we should use in this kind of lawsuit and to prove epidemiological nexus. We showed the judge and society several actions and omissions that the tobacco industry had throughout the years. They are all described in the lawsuit. They're much proved through a lot of documents and evidence. And we know that, but just to mention a few, the denial of the harms of smoking, the denials of the harms of alcohol smoking, marketing to youth. So we have a lot of proofs of that. And so it is, in this way, it is an opportunity, not just the states to protect the public health and to have the reimbursement of the costs of all these diseases and of this burden in public health, but it's an opportunity to disclose to the society the conduct of the industry through the years. So to make tobacco industry accountable in a social and historic perspective, because most people may know that smoking causes diseases, but sometimes, or maybe most, they don't know the history behind that. And we are having the opportunity of also showing this through this lawsuit. The current status of the case is that the judge has ruled on the production of evidence now. She denied all the evidence that were claimed, but and the industry filed motions for qualification of this decision, to which we have responded, and we are now awaiting the judge's decision on these motions. And what comes next is that the industry can appeal from this decision that denied the evidence they wanted to produce. But if they don't get suspensive effect from the Court of Appeals, this case could be or may proceed to judgment. So it's possible that till the end of this year or the beginning of the next year, if there is no suspensive effect granted by the Court of Appeals, it's possible that we have the first decision in this case, the sentence for this case. Of course, it can be appealed next, but it would be the first big, great decision in this case. That's it. Thank you very much. I'm at your disposal. If you have any questions about that. Thank you very much.
Thank you, Vinícius, for this last presentation. Daniel, I see that we have not much time left for Q&A, Daniel. I know you also wanted to have, and you had some slides for the end. But is it okay, Daniel, if we take a few minutes to go through some of the questions that were put on the Q&A function? So I'll start with the first question. I'll go right away through the order, and then I have a few other ones that came to me. But the first one's from Rosemary Hiscock. You mentioned, Kelsey, in the context of corporate death penalty, that this possibility as this legal option. So she asked, what would dissolving a company mean in practice? What could happen to the factors that start with the dismantle? What would be the process? And do we know of any examples at this stage moving in that direction?
So in the United States, I think the most recent example is from 1890. So I don't think it's going to be super instructive for us. There was a case about 5 years ago where some people tried to dismantle the NRA, the National Rifle Association, that made it fairly far in the courts. So I don't have a good example. I would imagine what would happen is the company the charter would be revoked. That's clear. That's what would happen. But then I would imagine the company would be forced to sell assets as a form of, a fee to give to its victims. So I'm not sure, a restitution, if you will. So that would be my guess, but I don't think we know for sure yet.
Do any of the other panelists want to comment on that concept of a corporate death penalty under civil liability? No. The next question from David Shalom is about this government's responsibility or liability or accountability for not protecting its citizens from the harm caused by nicotine addiction and tobacco consumption effects on health. And I mentioned that also in the context of, we know from other international treaties so the International Covenant on Economic, Cultural, and Social Rights, which has been ratified by most of our countries, in the general comments to address the health article in the treaty, and the general comments are basically authoritative interpretations on how to implement that article, they do mention that governments fail to protect the right to health of their citizens if they don't take actions to reduce tobacco use and nicotine use. So I'm wondering whether, I think it's a legitimate question, and I wonder what your thoughts are on that. What responsibility should governments have to even go further in protecting, or their liability for not doing enough for their non-citizens when it comes to protecting their citizens? And that was to all the panelists.
I would say that in Canada, the courts have been used by in a lot of other health areas in order to make policy change. So, for example, not necessarily to public health benefit. For example, cannabis is legal in Canada as a result of court action. There have been lots of areas where groups have challenged federal laws or provincial laws on the basis of their inconsistency and been successful. This does not seem to be an area where tobacco control has focused its efforts. I think that the costs have been a bit viewed as a barrier. I mean, I look at, for example, at the ruling that we had in Quebec about tobacco companies, which said they failed to warn, et cetera. And I wonder why there isn't pressure in the courts to make sure we have better warnings on alcohol or cannabis or junk food or whatever. So there is a definite resource issue and kind of maybe a cultural thing within us. But I think I would receive that question as a challenge, that maybe we should expand our strategies, our advocacy strategies into that area. It's been done for other groups.
So that leads to my next question also to the group. And I don't know if others want to comment on that specific comment, but the report suggests that a survey was sent to parties, and a number of parties even stated that they fully implement Article 19 of the FCTC. Would you suggest that? My sense is that not enough governments or countries maximize on what litigation or Article 19 offers to address tobacco control or health. But do you have any thoughts on that?
So I have some thoughts on the nicotine thing that I wanted to bring up, but I think so there has to be a harm, right? And of course, addiction is in and of itself a harm. I think we can agree to that, but I do think the courts might have a little bit of a harder time. I mean, if someone dies from lung cancer, that's a pretty clear harm. And I think addiction is a little bit harder to define and see. So I think, in a hypothetical law school exercise, I think that's a very interesting question. And I think, the sort of concept of progressive realization is built in here also. As we move forward along the path, I think there will be more and more opportunities. And that's what Cynthia said as well, is, maybe we need to get a few focused on cigarettes first, and then we can get a little further. I do think it's a very interesting question and something we should be giving more thought to.
If I could just jump in on that, I mentioned there were two Quebec class actions. One was for cancer and lung disease. The other one was for addiction. They were found guilty of causing addiction through but they couldn't assign damages to it because it was too, as opposed. The other complication is it was only moral damages, not the financial damages of being sick. But there is a case, the Canadian case stands as an example where the companies were found guilty on the specific issue of failing to warn about addiction and misleading people about the dangers of addiction.
Thank you for this. There's a few more questions that I'd like to, if it's okay with the panelists, Is it okay to stay a little longer? You're okay, Danielle? Okay. So if I may address the next question to Vinícius. So there's a few questions, if you could address them at once. On what grounds did the judge deny the request for public disclosure? Did Brazil appeal this? And did the judge deny the plaintiff's request for discovery? And how does that allow the case to proceed?
Sorry, I don't think I understood the question. Could you just repeat, please?
It's on the chat box. So on what grounds did the judge deny the request for public disclosure?
No, actually, she didn't. It's not about a public disclosure. The lawsuit is public, so you can even assess that. It's not that simple, but I could even share with you the links here is in Portuguese, so it's not that easy, but it's total publicly. And we have there is a website that has a summary of the case, but it's also in Portuguese. If you want, you can assess that and read. What she denied was the evidence that the defendants want to produce. And there were a lot of requests of evidence that had nothing to do with the case itself. It's kind of a strategy of the industry. They try to use diversionism, you know that, and they requested a lot of evidence that, and we made the case by the first petition. We had a lot of documents and relied on Surgeon Generals, and also of course we requested some evidence, and but I can say that there is no damage for us. There is nothing that is not good for the plaintiffs, and there is nothing to do with disclosure in this case. The case is public, and we use the case, the documents of the United States that was disclosure, so there's nothing about that.
Thanks. We'll have one more question, then Danielle, I'll let you close up. You use your last slide, but Danielle, you mentioned the Article 19 decision. You touched on it a little bit. Cynthia, you mentioned all those cases in Canada, all these expertise and experience in litigation, but still challenges and not enough outcomes from a public health perspective. So, Danielle, are there things you'd like to see in the decision that will be proposed, or is anything coming up in the decision for this COP that could help countries like even Canada forward with their Article 19 implementation and the use of litigation? And then I'll let you use your last slide, and then we'll close up.
Thanks, Laurent. Well, if it is a yes or no question, my answer will be yes, and I will love to see as much as could be translated, but this is quite ambitious. But let's say that the invitation is for governments, and I see that some of the questions were addressing some hesitations, to really go in depth of the current recommendations of the comment and bring what is feasible for them to advance and translate it into a decision. That's the way governments speak. It's not a matter, all the documents have good things, have bad things. This report could be, as I see, as the Global Tobacco Treaty also recognizes, it's an evolving document. It is not perfect and requires that all came together to address the different layers. One layer that has been resounding a lot is administrative liability as a path that Global South countries could take while initiating other civil or criminal actions. This could be a potential path that could be taken in this upcoming COP. The human rights approach is another path that some countries in Latin America, for example, are quite advancing. The thing is that it has not been as much utilized for tobacco control itself. But finally, I will bring again, because that resonates a lot with me, what Cynthia brought. Liability is a tobacco control measure. So I feel that definitely needs to be the big message for governments, to translate it into ways that liability could be seen not only as a legal tool, as a tobacco control measure.
Thank you, Danielle. And so I know you have another slide we're going to use for closing. So in order to avoid going back and forth, as we've already run out of time, I just want to point out that there will be two webinars again, you have information on the chat box for people who want to register for it. One on the October 22nd, it's a joint Pan-American Health Organization and Corporate Accountability webinar on the strategies of the Americas, and the launch of our 25 U.S. Tobacco Industry Interference Index, also co-hosted with Corporate Accountability, and that's on October 30th, and the information is on the chat. Danielle, I understand you were going to close and you had a slide for that? Or do you have a...
Thanks, Laurent.
And I'll give you the last words, Danielle.
Thank you, and it will be brief. So as I start the webinar with this mini-series concept, this is the last episode, and you will see in the slides that it says to be continued December 2025. Definitely, what will happen in November will allow to see how much of the current messages that are in this screen, but I will just take the words from the belated president, Mujica from Uruguay. In the world, 1 million people die each year for smoking tobacco. This is a mass murder. I feel that quote from belated President Mujica says a lot, and liability is a path to address that. So it is time to make big tobacco pay. All the attendees, and I much hope that this webinar could be amplified as much as possible in the lead up to these meetings, could continue contributing to shape the way this article could transform. And thanks a lot for the engagement and for being here with us. Thank you.
Thank you, Danielle. Thank you, everyone. Thank you to the panelists. And look forward to working with you for